sitting of the Supreme Court of Nova Scotia, the Honourable Justice Michael Wood presiding, is now open. God save the Queen.
Good afternoon, everyone.
Good afternoon, Lord.
All right, let me get my little list of attendees out. According to my notes, we have essentially 5 motions being dealt with today. 3 by the monitor, single notice of motion, but 3 different motions within that. We have a motion by Stuart McKelvey, and we also have a motion by Representative Counsel on behalf of the official committee. Did I miss any motions? Is that what everybody expects we're dealing with today? Okay. And we have present Mr. Chasson. You're here on behalf of Stuart McKelvey, obviously. Mr. Niedermeyer, you're here for Jennifer Robertson, and I assume the other related entities?
That's correct.
There's a number of trusts and companies that are referred to in the materials?
Yes, that's correct.
Okay. And Ms. Pilon, you're here along with Ms. Hamilton? And I think Mr. Nicholson will be joining us shortly.
He will be running in.
And you're here on behalf of the monitor. Mr. McDonald, you're here as representative counsel. And do we have Mr. Azef and Mr. Iqbal by phone?
Yes, my lord. That is Mr. Azef speaking. And I'm not sure if Mr. Iqbal is joining yet. But
Okay.
Yes, my lord. Mr. Iqbal is present.
All right. And Mr. Hill, are you here for the CRO, Mr. Wedlake?
No.
Okay. I just took a shot in the dark because I wasn't sure who you were here for.
A good shot, but
Yeah.
it missed, my lord. I'm here for 1009926 BC Limited.
Okay, so you're here for the BC company. All right, great, thank you. And then that deals with everybody in the courtroom. On the phone, I think we have Mr. Linthwaite.
Yes, Your Honor.
And you're here on behalf of whom?
POS Connect.
Okay.
One of the third party.
Yeah.
One of the third party for payment providers.
Right. And I have a note here, Mr. Holdsworth, are you here as well?
Yes, Your Honor. With Mr. Carey for custodian, one of the third
Yeah,
party payment
yeah,
providers.
so,
Your Honor, to be precise, we are on for Villarify Labs Inc., custodian, Jose Reyes, and a new entity, EPAD, or Registry Inc., whichever one refers to as EPAD.
yeah, okay, so all 4 of those entities, right?
Right.
Okay. Have I missed anybody? Okay, that's a good start. Now, I thought, unless some of you feel differently, that I might deal with the motions essentially in the order in which they were filed, which means that the Stuart McKelvey motion to be removed as counsel would be the first one I would deal with. Then I would deal with the motions brought by the monitor, and then thirdly, the motion brought by representative counsel. Does anyone think we should do it in a different sequence? Okay, hearing no objections. Mr. Chasson, your motion to be removed as counsel for the applicants. Is anyone here objecting to that? Let's start with that. Okay. Now, as you know, the rule you're moving under requires that your clients have notice of the motion today. I take it they've been notified?
That is correct.
Okay. And your basis for your removal is set out in the correspondence, and I don't see any reason not to allow the motion, so I will grant the order removing Stuart McKelvey as counsel for the applicants.
Thank you, Lord.
Now, just one housekeeping question, Mr. Chasson. It may come up again later. Is there any issue with respect to, I'll call it taxation or approval of your fees? Is that envisioned that there is going to be some hearing at some point to look at that question, or is that a done deal? I don't know. That's why I asked.
Not to my knowledge, my Lord.
Okay. Ms. Pilon, is that right? He's paid whatever he's paid, he's billed whatever he's billed, and there's going to be no necessity to review that further?
That's right, because in the initial order, it's not the debtor's counsel
Yeah.
that's subject to taxation.
That's right. That's why I asked. Okay. Well, then I guess you really are free to go, Mr. Chasson. You're welcome to stay if you want, obviously.
Unless your Lordship needs me in the room, I would rather absent myself.
I don't see any necessity for that.
Do you have a form of order for signature? If not, I can certainly forward one up to
I'm
you.
sure you probably filed one. Let me see.
I'm sure we did.
Yes.
I have one here.
Yeah, I have a, we're not equipped in this courtroom to issue it from the bench, but I will issue the form that you filed.
And that's fine. There's no urgency, obviously.
Yeah, okay, I'll set that aside. Okay, so now let's move to the motions brought by the monitor. Now, within that package, there's 3 different motions, and I'll call them, the first being the preservation order, dealing with assets of the estate of Mr. Cotton, Ms. Robertson personally, and a number of other legal entities. There's also the motion directed to third parties to deliver various things, documentation, in some case assets, which a number of people are participating in. And then the third is the motion terminating the CCAA proceeding and making the transition to bankruptcy. Do we want to deal with them in that sequence, Ms. Pilon? Or is there another way you want to deal with it?
In your hands, we can do it that way, or if you'd like to deal with the third-party processors, and then some of them may drop off, or...
Well, I'm going to start with the preservation order. And so, Mr. Niedermeyer, you're here on behalf of all of the parties to whom that order would be directed. Is that correct?
That's correct.
What? And is the order going to be issued, in your view, on consent? Are you consenting to it?
I am, but I haven't seen the final form of order. Mr. Nicholson hasn't arrived yet with it, so I would certainly be happy if you want to move on to deal with the other motion first, because as Ms. Pilon noted, some of the other people on the call might then just drop off.
Okay, just we'll come back to that then once the, what I'll call the more final version shows up. So let me just take my notes related to that.
I can just speak to the paragraph, and Lee should be here in a moment if that works for you, or there's one paragraph that I think we have amendments to. Again, in your hands. Do you like to move on to the...
Well, I have a couple of points on it, but now that you're talking about it, let's deal with it. What paragraph in your original form of order are we?
There's been a significant change, though, since you filed it, though.
I'm sorry, my lord. Perhaps we should wait, and we'll deal with it at a quick break to show Mr. Niedermeyer the one paragraph that is being changed with respect to some
Okay.
accounts.
And
Sorry to jump
if
off
you're
the-
going to be chatting with him, why don't you also chat? You've got a provision in here, at least in the draft, that purports to give notice to people who are not here, essentially enjoining them from doing certain things. I'm looking at paragraphs 13 and 15, the banks and the exchanges. I take it none of them have been notified of today?
They haven't, but we've dealt with that in the traditional sense of the Mareva, where you would notify them after the fact of the freezing, and they could come back if there are any questions with respect to it. So that's why we did it in that sense. It is on consent. Behind the scenes, we have received disclosure from Ms. Robertson of the identity of the various banks that are to be included in there, and that has been updated from the form that you are seeing in draft in the materials. Okay. And also the potential exchanges to be advised. And then we anticipate we'll be working together with Ms. Robertson and going forward to each of those groups to determine third-party verification of the accounts or any information.
Okay, well, we'll talk about that when Mr. Nicholson gets here and Mr. Niedermeyer can see the form of order. All right, I guess that does take us to the third-party payment request. And Mr. Carey, I was given just almost before I walked into court a copy of your letter expressing concerns about the timing of the notice, the timing of the hearing, and some substantive concerns. So I understand, I'll hear from you shortly, but I understand you're concerned about some aspects of this. Mr. Linthwaite, on behalf of your client, are you opposed to what's being requested in some fashion?
Well, I share my friend's concerns about the timing, but that aside, I think it would be appropriate. I've been in discussions with Ms. Pilon, and I'm fairly confident that we're going to be able to arrive at a consent resolution. But my client can't consent to the language that's in the order that was put before you in the notice of motion.
Okay.
And so what we're proposing is essentially a two-step process. And I can return to that. If you're just doing an overview now,
I'm just doing an overview to,
Yeah.
some people are just listening in to hear what happens. Perhaps others are, like you, are going to be a little bit more substantive. I think I have a sense of your general position.
Yeah.
Then, Mr. Hill, I guess you're the only other person participating on behalf of the third parties. What's your...
Thank you, my lord. I've had discussions with Ms. Pilon, and I think I haven't actually seen the change yet, but we've agreed on a change just extending the amount of time that my client will have. There's no issue with responding. So I think we're going to be okay.
Okay, so you're anticipating some sort of consent language that hasn't been completely finalized yet?
Well, I think I've been told what it is, but I haven't seen it.
Right,
so,
okay.
Yeah.
Okay, so let's, Mr. Carey, seems to me that you may be, at least based on your letter, the one that's perhaps most concerned with proceeding today. So I'm not 100% clear from that letter what you're asking me to do today, or what you would like me to do today. So why don't you summarize that for me?
Well, Your Lordship, there are two issues we have with the material that we were given last Tuesday. And one of them is in the material is called the draft transition order, which has got to do with the morphing of the current application into a bankruptcy application.
That deals with the provisions related to Mr. Ray's?
That's correct.
Yeah, okay.
Because, the new order, which is being proposed, now imposes, puts Mr. Ray's charge behind the director's charge, which is contrary to your order of February 22nd, in which there is no such priority given to the director's charge.
Okay, well, we'll come back to that transition order and that material related to Mr. Ray's, if you don't mind, when we get to that order.
No, that's fine, and I'm just pointing out that we are concerned about that.
Yep, okay.
And then the second thing we're concerned about is the what's called the materials you received, the draft third-party payment processors order, and particularly paragraphs 6 and 7 of that order.
Yeah.
And I'm unfortunately being put in the position of having to advise you about things as opposed to having proper evidence for you because of the timing, and that's my concern with the timing of this. And indeed, it's only because another matter was canceled in Toronto that I'm able to appear before you on the telephone today. So otherwise, I'd be in court in Toronto doing something else.
Are you prepared to proceed today, or are you?
Well,
I realize
my concerns and suggest that these orders be put off until Ms. Pilon and I have the time to address language or wording of the orders that might be mutually agreeable.
Okay.
As opposed to simply having the orders presented to us in a fashion which we don't find agreeable, but we can perhaps find a middle ground and come to orders that would be we can consent to. We're saying we can't consent to the existing orders, and indeed we oppose them. And for example, in paragraph 6, the order, the way it's worded, gives the monitor here the authority to basically seize all of Miller Fines and EPAS records. It says that they shall deliver all books, documents, and account records and any other papers, which is, in our view, seriously overreaching. And don't get me wrong, Miller File Labs and EPAS and Custodian Inc. have no objection to providing information to the monitor. And indeed have done so and have been, quite frankly, amongst all the payment processors, the only ones that have actually handed over all the assets, including some of their own assets, because of the historical baggage associated with certain bank drafts to the monitor. And that's why those assets are segregated in a separate account, approximately $720,000, subject to further arguments on the ownership of those funds. And that order just has to be redrafted because it simply overreaches the way it's stated now. And
you and Ms. Pilon haven't had a chance to sort that out, I take it?
We haven't, and part of it is because they only got these draft orders on Tuesday.
Yeah. Okay.
And indeed was unaware of the date of this motion until It might have been late Monday night, but I don't think I read it late Monday night. I read it Tuesday morning. And of course, the other part of the order is that within 5 business days, biller, file, and EPAD shall deliver a property in the possession of capital P properties defined in the original order. This belongs aware that biller, file has no property. We've had this discussion long before the bank drafts were handed over, and EPAD, which she doesn't know, but I can advise, also has no property and probably is owed fees from Quadriga as a result of its activities with it. So, I mean, in the circumstances, Your Lordship, custodian, biller, file, and EPAD, they're unpaid third-party suppliers to Quadriga. This is the situation in which they found themselves. And the order which erodes their security on their funds is a transition order, and this order, which overreaches by compelling them to hand over what looks like original documents to the monitor, but they have no authority, in my respectful submission, to make such a demand, are things that they would can consent to, would object to. But on the other hand, we feel we could probably work them out with Ms. Pilon if we're allowed some time to do so.
Ms. Pilon, what do you say about the idea of giving you some time to see if you could work something out? As opposed to hammering out the wording today, or issuing it as proposed?
Well, I did respond to my friend with respect to some of the issues that he had, including the fact that we're prepared to take copies, obviously, instead of his reading of it, that I'm taking the originals. For each of these third-party processors, my lord, we have been reaching out since February, and I know we've spoken a few times. Each time we're here, quite frankly, about the current status and the need to have people to pay attention to the monitor and the potential information that's necessary. And so for many of these individuals, either we didn't get complete responses, or in the case of Billerfi, no responses from Billerfi directly on some of these issues. And so that's why it was necessary for us to bring the motion to get people's attention, and quite frankly, it has achieved that goal, because we now have people focusing on this. If I might just give you a bit of background, because then I'll deal directly with Mr. Carey's position. For the third-party processors, they're either in 2 buckets: people who are formal third-party processors, like Billerfi or POS, or insiders at Quadriga who seem to have incorporated some entities, and those entities were then used, the bank accounts of those entities were then used for third-party processing, because Quadriga itself was having difficulty, as we understand it, maintaining its own bank accounts. So that you have those 2 buckets of third-party processors. Some have formal governing agreements, POS and Billerfi and custodian, for example. Others, we need more disclosure to determine what terms, in fact, govern their relationship. And the reason why the third-party processors' cooperation and information is important to the monitor and to the affected users is twofold. One is the statements are important because they show the flow of funds coming in and out of these third-party processors. That helps us with asset recovery, it helps us with tracing of assets, and potentially the future claims process. And then balances. If there's any assets, Quadriga property remaining in any of these accounts when the music stopped on February 5th, we need that to come back into the disbursement account and be made available to the affected users through the claims process. And the fact that it's continuing to be held outside of the reach of any Quadriga or the monitor is difficult, and we need to have it come back. If people have arguments with respect to this isn't really Quadriga property, they have claims with respect to some sort of set-off or fees, we've invited them to provide that type of information in accounting so we can have that discussion. But we do need at least upfront the balance of the Quadriga property coming, and then as you'll see from the form of the order, there's an ability to continue that discussion with respect to what may constitute Quadriga property. But it's time for the information to come forward, and the ongoing hurdles that are being placed in front of the monitor in terms of we need this, I need an indemnity, I need Mr. Kinsman's passport before they're...
That's not what Mr. Carey's talking about.
So for Mr. Carey, I can deal with it quickly. I'm happy to have a final conversation with Mr. Carey and we can determine the terms and then submit it on a consent basis with you. I get the sense from Mr. Carey's response that in fact BillerFi is prepared. BillerFi and EPAD are prepared to provide the statements and the information we're requesting, provided it's on a copies basis and not originals.
Is that right, Mr. Carey?
Well, Your Honor, most of these records are in electronic, so they'll all be copies to that extent.
Okay.
And what the current order is drafted, what the team indicated, we have to hand over everything, including data documents. So when I say we're prepared to hand over information, yes, they'll all be copies, but we're going to maintain our own internal records and not hand those over to a third-party monitor.
Okay, but it sounds like then you're saying the same thing as Ms. Pilon, right?
That's correct.
Yeah, okay. So subject to the language getting massaged to reflect that, that's the issue of not providing original records, but rather copies. Was there another concern that you had on this production issue, Mr. Carey?
Well, only one, Your Honor, and that is, it appears that in some respects the monitor may want an accounting, and BillerFi, Custodian, EPAD, they're all the same, really. Different corporations, but I mean, none of them have any property. They're Custodian for certain is owed money. I say for certain, we say it's owed money. EPAD appears that it may be owed money. To ask them now to go and do a complete accounting without compensating them for the time and effort it takes to do an accounting, seems that sort of insult to injury.
I don't think the order doesn't require that. Are you looking for an accounting?
Well, my lord, what we are looking for is the statement. So in particular for BillerFi and Custodian, who are apparently in the business of offering these payment processing, and their agreements provide that they are to give reporting, I would think, in fact, it would be the easiest for them. They should have it in their functions, their reporting functions. So I didn't completely understand why it would be so difficult for them to do that, and that was my follow-up question to Mr. Carey. Why would it be, and what are we talking about in terms of length of time, and what does he say are these purported expenses that are necessary to provide that information? Expenses are not provided for in their agreement as a precondition to providing the reporting. This is their business. We're just asking for them to provide that reporting so that the monitor and the affected users can know what could be available to them.
Here's what I am inclined to do. If either one of you want to talk me out of it, then so be it. Mr. Carey, you are right in your correspondence when you point out that you were given short notice. You were given less than the notice required under our civil procedure rules. You are also correct when you suggest that you ought to have been consulted on timing, because our rules do require that as well. But having said that, as Ms. Pilon has outlined, there are things that need to move along in this process. And so what I'm inclined to do is to put this portion of the motion over returnable on April 18th at 9:30 in the morning, which has already been set aside for this matter. If you and she sort out your language on the order between now and then, so be it. Otherwise, I'm going to issue an order on the 18th at 9:30 in the morning. How does that sound, Mr. Carey?
That sounds completely acceptable.
Okay.
Lordship, it'll give us time to work things out. I'm pretty sure we've always managed to come to agreements in the past.
Okay, and it sounds like you're not very far apart. And if you do it, obviously, by agreement before then I'll simply issue the order. And for the 18th, if you do, for whatever reason, want to participate, Mr. Carey, you can do it by phone again to save travel.
Thank you.
Okay. Ms. Pilon, sorry, is that okay with you to do it on that basis?
That is fine, thank you.
And then, Mr. Hill, maybe leave yours on the same basis. I know you're finalizing the wording, and maybe it'll get finalized this afternoon, but if for some reason there's anything left unresolved on the language of your order, I'll deal with the thing once and for all on the 18th.
I'm sure it's going to be resolved very quickly.
I expect so.
But, certainly, I've made a note for the 18th.
Okay. Mr. Linthwaite, what about your situation? Again, from your comment earlier, it sounds like you're a good portion of the way towards some sort of an agreement. Are you there yet?
We're not there yet, Your Honor. I think an adjournment of the aspect having to do with POS to connect to the 18th would probably serve the same salutary purposes with respect to Bill 5.
Okay. Ms. Pilon, do you take any issue with either of those being dealt with in the same way?
Well, for POS, I think my understanding was they were agreeable to that they will be providing online access to Mr. Kinsman.
Oh, yeah, my friend's correct, actually. That's part of the two-step process I was envisioning. Yeah. Sorry, I interrupted you, Ms. Pilon.
Right, but I don't think that's in the order, is it?
That's been modified because...
Oh, you've now got a new wording. Okay.
Yes. So Mr. Kinsman, the way in which I understand POS records, it is online, so Mr. Kinsman would get access to it online. POS is suggesting there is no other documentation, but once Mr. Kinsman gets access online, then that's fine. We can confirm that and see if there's any other information that's required. And there is a balance that has been acknowledged by POS that is available to be paid. There's an issue with respect to accounting there, or if there's any type of fees or expenses that are being addressed in that. What I would prefer is not to lose the time from here until the 18th. Mr. Kinsman could get access online and start dealing with that, and then we could restrict what, if anything, we need left over with respect to an order there. The issue on online access, Mr. Kinsman is the monitor. He may be the trustee shortly. He is the court officer. He, in that capacity, should be provided with online access. My friend suggested there's some know your client additional information, including copies of passports that are required. Our preference is that not be a precondition to the monitor getting access online. Mr. Wedlake has been assisting with respect to that and confirming to POS that Mr. Kinsman is the appropriate representative for gaining online access. And quite frankly, a Quadriga person would have had online access, but we don't have anyone left. So Mr. Wedlake has deputized Mr. Kinsman to take on that role, and my preference would be that we use the next 10 days and permit that to happen.
So you're suggesting that whatever the form of order is that's now been revised, you'd like that issued sooner rather than later? Or is the idea that by consent he will be given access because he's passed through the necessary screening processes to get eligible for access? Where is it?
I'd take either, but if my friend would take that consent that way, that would be fine. If he requires the language in the order, we can deal with that this afternoon.
Mr. Linthwaite?
I'm content to provide Mr. Kinsman access on the basis of language that my friend and I have agreed to. My client can't consent to the rest of the language in the order, and that's what I'm suggesting should be put over until the 18th. Okay. So my friend can perhaps dictate or read to the court the language that she and I have agreed upon concerning access. My client's concern with respect to access was simply that we do have know your client requirements, and furthermore, once an individual is logged into the system, they can almost literally send the money anywhere in the world. So we just need to be careful. And so I think the language that my friend and I have agreed upon accomplishes that, and then once Mr. Kinsman's in, he can see all the documentation available. If anything else needs to be dealt with, it can be dealt with on the 18th.
Okay. Do you want to read that language in, whoever has it?
What I have is Mr. George Kinsman of EY, Kinsman, is authorized and permitted to access the online Quadriga account with POS Connect, the POS Connect account, on behalf of the monitor to obtain any documents and accounting records and any records and information related to capital P property that POS Connect holds or previously held located in the POS Connect account, and POS Connect shall have no liability or obligation to any party in respect of any actions taken or omissions made arising from kinsman's or the monitor's access to the POS Connect account.
So, my lord, it's part of paragraph 9. We had tried to morph paragraph 8 was in the existing order, which provided the overall disclosure. For purposes of today, I'm happy to take that paragraph out and just refine paragraph 9 back to the issue of access by Mr. Kinsman.
And using the language that was just read.
That's right. I can crop it back to that, so that way if Mr. Kinsman gets in there and starts meddling, POS won't be responsible. But otherwise, then that gets him online access in the next 10 days, and then I will work with POS counsel for the rest.
All right, so you're happy with that, Mr. Linthwaite?
Yes, if the material that I just read out goes into an order and the rest is left to the 18th, that's fine with me.
Okay, so we'll include that then. All right, so Mr. Linthwaite, you're welcome to stay involved and listen to this. It's open court, but I think that deals with all aspects of your matter, at least for today's purposes.
I think I'll stick around a bit.
Okay.
Trouble court.
Well, and if you think you can add something later, by all means, you can speak up. And likewise, Mr. Hill, same with you. I think your matter has been addressed, but you're welcome to stay and participate.
So I'm going to stay and learn.
Okay, good. All right, so is there anyone else here speaking on behalf of any of the third parties? I don't think so. So let's just quickly go through the ones then, Ms. Pilon, that are outstanding in terms of not having been discussed yet today.
In paragraph 4 of the block line that we just passed up to you, this deals with Mr. Hill's client.
Yeah.
So 1009926BC. So that the change there is to provide 10 days instead of 5. I hope that's what it says there.
It does say
10
that.
days instead of 5 to provide the statements and also to provide the property that may be in company's hands. And that's what we've spoken with Mr. Hill about. The other aspect of 1009 that's in the monitor's report is the bulk drafts that have been the subject matter of previous discussions, including the banking arrangement order. And so that we have 1,004 bank drafts that were with STUMAC and now are in our hands, in EY's hands. All those bank drafts, they are available to be deposited into the disbursement account. On the basis the assignment agreement appears to have relinquished any rights that 1009 may have initially had. And so it's our proposal that we are going to be providing that and depositing those drafts into the disbursement account. We gave an opportunity for 1009 to have one last chance to advise if they had any alternative position with respect to that. I understand from Mr. Hill they do not, but I will let him speak about that because it's our intention to deposit the bank drafts then this week.
No issue with the deposit, my lord, but simply no issue with the deposit. In terms of anything else, I don't have instructions as yet. And in terms of paragraph 4, where it talks of all books, documents and accounting records, then I take that to be copies of, and we have no issue.
Yeah, Ms. Pilon is nodding to that effect. Okay. All right, so that deals with Mr. Hill's client, the numbered BC company. So then VoPay International, I'm just going through in the, maybe I'll go through in the order of the black line order that I now have. So VoPay International.
VoPay had provided reporting, the statements had been provided historically, and that's why VoPay, the paragraph is limited to just the amount to be paid, and they have consented to that occurring. So while they're not opposing this order being entered.
There had been some, I think in their correspondence, some discussion of deducting service fees.
We understand that now
gone.
they are prepared that this full amount is going to be paid to us.
So you've had correspondence with them or some communication that says they're prepared to pay this amount?
Yes.
Okay. All right.
So there's nothing further there.
Okay, so that one's fine. How about the Alto Bureau de Change?
I may need Mr. Nicholson's help with this one on the Alto Bureau. We have attempted, do you want to take
Yeah, sure. My lord, on Alto Bureau de Change, they're kind of a unique situation where they were involved in a one-off transaction with Quadriga, where Quadriga provided them 2 installments totaling $190,000. We have an accounting of what was dispersed from those funds, and there's one discrepancy in the accounting, and there's a reference in the 4th report that they're either holding X amount or another amount.
Right.
If you look in the exhibit, it's Exhibit A-B in the 4th report, there's certain transactions that are listed as pending. And we are unsure at this current time whether those those transactions were actually dispersed. But either way, they're holding either $20,000 or $30,000 of Quadriga property. We have communicated with Mr. Stella. That communication is detailed in the 4th report. They did not respond to our latest communication in early March regarding this issue.
Did they respond to the motion materials?
And they have not responded. We have served them both by registered mail at the head office and the location at the Alto Bureau de Change. And we also emailed the motion record on the service email on Monday night to Mr. Stella.
Okay. All right, and the order is simply asking them to deliver any assets they have without specifying what the amount of those assets would be.
That's right. They could. We have a paragraph at the end of that order regarding it that if there's any dispute around the amount that they are holding, that motion will be returnable. But this order would direct them to return any property that they are in fact holding to the monitor to be deposited in the disbursement account.
Yep. Okay. All right. So that deals with Alto. We've dealt with the numbered BC, BuilderFi, EPAD, POS Connect. So then I guess the last one is WB21, and that includes Black Banks Inc. and WB21 Property Limited. Have you heard anything from them since the motion materials? I saw what was in the monitor's report about correspondence with them.
Right. So they you can see they have acknowledged the fact that they were a processor.
They have $11, don't they, or something like that?
There's somewhere between $11 and millions
Yeah.
that we say are there. They have acknowledged they were a processor. They have acknowledged they have an account. They did not respond since service by email, and we attempted to serve them at the corporate address in the corporate records. They had an Ontario address. When we went there to serve, there is no office there. Mm-hmm. So, but we have served by way of email, and they have communicated. That is their mode of communication with us to that point. And we appreciate, we have an Ontario entity and we have a Singapore entity. We appreciate, this may be phase 1 or step 1, but we'd like the order so that we can at least determine if there's any further steps we need to be taking if this is purely dealing with the Singapore entity.
Well, you're only asking for any property they have in their possession as well as any account statements, so I don't have any difficulty with the request. Administratively, Ms. Pilon, the time period for providing materials should start on the date they're served with the order, as opposed to the date of the order, because maybe they don't get a copy for 3 weeks for some strange reason. Is there any reason why we wouldn't switch all the time periods to 10 days as we did with the BC company?
That's fine.
I mean, 5 business days is really not a lot of time, particularly in this case, there's someone in Singapore. So just for consistency, why don't we make them all 10 days and they all run from service of the order?
That's fine.
Okay.
Thank you. And then I will work with my friends on the phone to finalize any other language, and then perhaps we can just submit it on a consent basis.
Yeah, okay. Anything else now about this order? Seems like we've worked through what we need to.
No.
Okay. So do we want to go to Mr. Niedermeyer's asset preservation order?
For that one, we may need just a 5-minute recess, if you don't mind, to speak to Mr. Niedermeyer to show him that.
Oh, right, yeah, okay, fair enough. We'll come back to that one then.
My apologies.
No, that's fine.
We're trying to get through everything and all the last minute changes.
Okay, so the transition order. I guess let's start on the basis, Mr. Carey, you had some concerns about the impact on Mr. Ray's, and we'll come to that. Does anyone else have any objection or issues with any aspect of what's been called the termination and bankruptcy assignment order?
Ms. Robertson takes no position on that.
I'm not hearing anything else. I have a few points myself, but if no one else has any, then why don't we go through some of the questions that I have, if that's okay?
Yes, absolutely.
And some of these are not necessarily specific to the wording of the order, but it's getting an understanding about the process, I guess. So when I look at the issue, and I alluded to this with Mr. Chasson, under the CCAA, there needs to be some sort of approval or taxation of various accounts, obviously the monitor's account, CRO's account, your account, Ms. Pilon, Rep Council. When is that anticipated to happen? Is that going to happen before the termination of the CCAA proceeding or at some point down the road?
So I think the big picture on the timeline that's remaining from here until we get to the formal and only the bankruptcy process, the way I would see it, my lord, is we have the CCAA now continuing. We have, if my lord grants the order today, we would have the bankruptcy triggered and the assignment would occur, and let's assume by April 12th, the bankruptcy proceedings for each of the 3 Quadriga entities could be up and running by way of these assignments.
Before the CCAA is over?
That's right. You would have it running as parallel for a short period of time, but the reality is most of the functions now with respect to the Quadriga entities would be happening through the bankruptcy.
Okay.
The CCAA would continue. We see it for a couple of purposes for the very short term. One is to address, we envision coming back before this court with a preliminary investigation report, because it's wearing the monitor's hat that investigation has been dealt with primarily. So we think it would be appropriate to come back to the court with that preliminary investigation report. So that would be the major last piece that is being dealt with in the CCAA. We would deal with any post-filing payables during this time frame that need to be quantified. There shouldn't be a tremendous amount other than the administrative costs, but from contractors or Amazon, those types of costs, those would be quantified and dealt with. And then we would come back to this court at the same time with the investigation report. We'd have the activities of the monitor and the reports, so that will be the 5th report, the activities addressed and approved at that point, and then any parties who are to be before this court for their fees to be approved, so monitor's counsel and rep counsel, would then come forward.
And CRO, I assume CRO fees come to
I don't think the CRO's fees are approved.
Did we not include that in the order?
No, I think we gave them a pass, but I believe it's just the monitor's counsel, and the rep counsel would then come before you, and that would formally transition and end the CCAA. Mm-hmm. And as you can see from the draft order, the way that formally happens is with this discharge certificate. So you would assume that would occur, then we would give people 7 days notice. It's our intention to file the discharge certificate, and that's the triggering event. So then your CCAA would formally end. But in the meantime, your bankruptcy is up and running. Your first creditors meeting is likely to have occurred. And then going forward, just in terms of the fees aspect of it, that would continue to be in the bankruptcy. Again, the trustees counsel and rep counsel would have their fees approved. At first instance, it would come through the inspectors of the estate. And then we have it coming back before this court for a final approval before the closing of those estates, so that there is coming back always to you for that. But from a practical point of view, the inspectors deal with it initially. So that's how I see the 2 proceedings running in parallel for a short time, and then bankruptcy up and running.
All right. Well, appreciate the overview. Now that you've raised the question, one of the things I was going to ask later on is it deals with the continuation of the official committee and rep council during the bankruptcy process. Where is the authority to have those entities in a bankruptcy, and in particular having the fees paid? Because I mean, obviously the the trustee, counsel to the trustee, those are all things that are, I guess, statutorily governed under the BIA. But the idea that you would have a group of creditors whose counsel get paid ahead of any of the other creditors of the estate is a concept that I'm not familiar with, and I'm not saying I'm opposed to the idea, but I would like to know where the authority is to do that.
And that authority has basically, it's come through the inherent jurisdiction through the CCAA, because that's where this transition aspect of it is coming from.
The court's authority under the CCAA is quite different than under the Bankruptcy and Insolvency Act.
Yes.
As I see it. I mean, the language for broad orders under the CCAA is well known. I don't know if there's an equivalent provision under the BIA. That's why I'm asking the question.
Right. And we have provided, there is the MF Global example that has been provided in our proceedings, where it's exactly that situation.
Okay, so
tab 7.
What tab of your brief?
Tab 7.
Okay. Which paragraph of the order?
Tab 7 at the back end of the tab is the actual rep council order. There were a few orders that were included in there from MF Global.
Okay, so let me just go to that one then. And which paragraph are we looking at in the order?
Paragraph 2. And that actually, that representation started in the bankruptcy order here, I believe. So paragraph 2, do you have that, my lord? It's November 14th, 2011 order.
Sorry, is it this one here I'm looking at in your materials?
It's tab 7.
Yeah.
And it's the back end of it, the last
Right, November 14th, yeah, I have it, yeah.
Customer Representative Council.
Yeah, I've got that.
And paragraph 2.
Right.
And that customer representative hereby appointed to represent all customers. In that case, segment was the Customer Representative Council, paragraph 3. And they had the opt-out, similar provisions of the opt-out as we have seen in the order that you granted in this case.
Mm-hmm.
So it provided that mechanic so that we would continue to have the global representation, because overall, then it leaves the overall, you still want the collective basis of these proceedings, both from the trustee's point of view, but also in this case, given the vast number of people we're dealing with, we still believe there is the benefit to having that rep council continue.
And so their fee is paid as a disbursement by the trustee? Is that how it works?
Well, in this case, we would still have it as coming out of the estate. So it wouldn't be coming out directly, it would be in a
no, I'm just looking at this order. I thought this order is paid by the trustee.
Yes.
So in this case, it was structured as a disbursement of the trustee, wasn't it?
Yes, I believe that's right.
And then it gets taxed with the trustees.
And it's always intended that it would continue to be taxed here.
Yeah, no, I understand that. I've never seen this type of structure in a bankruptcy, and I just want to make sure that if we're going to do it, that we have some basis for doing it, because it's a situation where the fees essentially are coming ahead of the unsecured creditors. And I realize Rep Counsel is going to be speaking on behalf of those unsecured creditors, but we might have opt-outs because the opt-out period hasn't expired yet, I don't think.
So far, we have 5 opt-outs.
Okay.
5. That Mr. Kinsman has spoken to each one of them to determine the basis for the opt-out, but so far we have just 5. And in fact, when we spoke to the committee and Rep Council with respect to whether they supported this moving from a CCAA and moving into the BIA, They did so, one of their conditions of supporting it was also that they continued to have this ability to come through rep council and have that central voice. And that's why, in terms of moving from what would be the flexibility of the CCAA to a little bit more administrative in the BIA, that was one of their concerns and conditions that they wished to express.
I take it the opt-outs have been given notice of today's hearing?
Yes.
So you're saying the authority to do this is some sort of inherent jurisdiction? Is that what you're saying?
Yes, I think that's all that I'm not aware of anything beyond that.
Okay.
My Lord, it's Austin Iqbal here, Rep Counsel. If it's of assistance, I could direct you to Section 197 of the BIA. It gives the court discretion to address costs incidental to any proceeding. And subsection 6 of that deals with legal services rendered to the trustee or the estate of the bankrupt, otherwise rendered, so there is a basis for that. And the legal costs in that context are captured in Section 136 of the BIA, which is the scheme of distribution.
Which thank you for that. Which it would explain why in the order you've referred me to, it's shown as a disbursement of the trustee.
Coming out of that.
Because that way it fits under that section. Can we do it that way here, do you think?
Yes.
Okay. And that way, I think it's
Coming within
it's
the scheme.
more consistent with the language of the BIA at that point.
And then we would bring forward both sets of fees for.
It would all come through at the time that the trustee was essentially passing its, I won't say passing its account, but taxing its fees, and your fees and rep council fees would all be legal fee disbursements because the rep council would be providing fees for the benefit of the estate, right?
Okay.
Mr. Iqbal and Mr. Azef, is that okay to deal with the fees on that basis?
Absolutely.
Yeah.
Absolutely.
Okay. Well, that answers that question then.
Thank you.
So now let me go to my other list of questions, if I can. More for interest, paragraph 3, which talks about a $25,000 deposit to the estate of Whiteside. Is that because they're unrelated to the rest of the Quadriga operation?
It's in the chain,
Yeah.
so you needed to have some assets in there to deal with the cost with respect to that, because you're going to have 3 individual bankruptcy
Oh, 3
estates.
separate estates, yeah. Okay.
Right.
I thought it was something along those lines.
So that was that's the more administrative part. We didn't want to have it as an insolvent group. And just to be, this order has been provided to the superintendent of bankruptcy.
Oh, it has, okay,
Yes.
good, because that was another question I had.
Yes.
Did they give you any feedback, any concerns?
None.
Okay. The next paragraph deals with Mr. Ray's, and Mr. Carey, you have concerns that this is adversely affecting your client's position vis-a-vis that $700 and some thousand disputed amount, right?
That's correct, Your Lordship. That money was provided to the monitor pursuant to your order of February 22nd. And paragraph 8B of that order states that the disputed amount, that's actually 778,213.94, would be held in a separate account by the monitor pending a determination of or resolution of the respective parties' respective rights, and could be held in a separate account. And the language also says each of Quadriga's and custodian's rights, entitlements, claims, and defenses shall not be affected by depositing the disputed amount in the disbursement account, and the separate account of the parties' respective rights, entitlements, claims, and defenses in respect of the disputed amount shall be determined as if custodian continues holding possession of a bank draft for the disputed amount. And that gave protection to custodian, and it was an order that custodian thereby agreed with. And pursuant to which it handed over the bank drafts. So there was reliance upon that agreement. The current paragraph number 5 is different, and it's different in a fashion which might be pejorative to custodians. One thing that jumps out is that the rate, now they're talking about simply giving raise a charge, and in fact I think it was custodian status, but raise a charge, but that charge is now subordinate to the director's charge as defined in the initial order, and that was never part of the order that he made on the 22nd, and it wasn't part of the, if I may use the term, the deal that was arrived at prior to custodian handing the bank drafts over, because in custodian's view, the bank drafts included some of its own money. So we would prefer, and would suggest it's necessary for this paragraph 5 to simply track the language of your February 22nd order.
Ms. Pilon?
I did write to my friend with respect to the reasoning behind this. So that paragraph is, in fact, the monitor was trying to find a way in which to maintain the isolated nature of that separate account from your banking arrangement order. We completely agree that it's intended to be separate and protected and available for the parties, for Mr. Reyes or custodian, to make arguments with respect to that separate account, and that was the spirit in terms of the original banking arrangement order. And in fact, this is the monitor's attempt to preserve that separated account, because once you move it into the bankruptcy, it, unless you give it some sort of charge or elevate it outside of the estate, it may get pooled in with the rest of the assets. And so that is our actual attempt to preserve the spirit in terms of...
I don't want to get involved in trying to draft on the fly here, but Mr. Carey's suggestion is to simply track the language of the earlier order. Is there a problem with doing it that way?
If you do it that way, it may not in fact be isolated. It could be found to be part of the entire bankruptcy estate, and or be ranking pari passu with the rest, and that's not what the intention was. If Mr. Reyes or custodian has a legitimate claim with respect to the fees, the term that the arrangements we made with respect to the $25 million worth of bank drafts coming in was the isolation of that. So there's two ways of doing it. One is this charge, which would isolate it and lift it above the rest of the assets going into the estate, or the monitor could continue to hold that account, and that would be the last function of that it's wearing, that as a monitor, and in the CCAA, holding that account outside. The concern is we don't know how long it will take to determine those issues. So if it happened within the next month when the investigation report's coming forward and the final steps in the CCAA, fine. But if it doesn't and that separate account needs to be maintained, it could continue on longer than the rest of the functions of the CCAA. And there have been occasions, and we have, for example, the CanWest order that's in the brief, that there have been occasions where after the termination of the CCAA and after the discharge of the monitor continues to take on certain administrative functions or roles. So we could continue to do that and understand that that's our only role, is holding that separate account, and all other disagreements or resolutions or hearings with respect to those fees would be dealt with in the bankruptcy.
Here's my suggestion, and hopefully you'll agree with it. Ms. Pilon, you want to get this transition order issued today, if possible, or soon, so you can start moving in that direction, right?
Yes.
But the issue of what's going to happen with this fund, as you've just indicated, that may take a little while to figure out how it's going to happen, and maybe even it gets dealt with differently than you've proposed in here. What if we simply don't deal with the raise money with this provision in this order at this time at all? Just take it out, and then there's the opportunity to either sort it out with you and Mr. Carey as to what it should look like, or either one of you bring it back at some point if the monitor doesn't want to have this ongoing issue. It just gives Mr. Carey and yourself a little more time, because I don't hear you saying anything different. you both agree that nothing in this order should adversely affect the position of Mr. Carey's client. He's just not comfortable that this language accomplishes that, and you think it does, but obviously you need to work that through. Is that a reasonable way to deal with it for today's purposes?
That's fine, and we can come back either with form of an order that on the April 18th time that we have with you, or if absolutely necessary at the last time when we're coming forward in the CCAA with respect to approval of activities, we can deal with it at that point.
Okay.
Is there any initial impression, if my lord is okay with the concept of the monitor's role continuing in that very basic means of just maintaining this account, I'm not sure if you have an initial impression with respect to that, because then we can go down that road and maintain it.
I don't, because this is the first I've heard of that as an option, so I really haven't really thought it through.
Okay.
I see nothing superficially objectionable about it, but that's not much of an analysis. So,
Okay.
Mr. Carey, can we deal with your client's position on that basis, that this provision would come out of this order for today, but you'll have a continuing discussion about how to manage that issue and get to a point where your client's claim to that money can get resolved?
That would be fine with me.
Okay. All right, so let's deal with that on that basis. Now, Mr. Carey, does that deal with all of your issues for today's purposes?
It does.
So, just like everyone else, you can keep listening or you can bail out. It's entirely up to you.
Well, if the court doesn't mind, we'll probably just keep tuned in.
Sure.
Just so we
No,
can
that's fine.
try to keep some situational awareness of what's going on.
Absolutely. It's also being webcast, so if you really wanted to lay back and not worry that we could overhear what you're saying, you could watch it on your computer.
Okay.
Anyway, I'll leave that to you. So carrying on then, Ms. Pilon, very, very minor issue, paragraph 6 talks about when you file the discharge, the proceeding is terminated. The language in the initial order was dismissal in paragraph 17. Is there a difference between dismissal and termination?
No, there isn't, so I can go back to the dismissal.
It seemed to me if the idea is that's when the proceeding ends, it just terminology, it made sense to use the same thing. But that's paragraph 17 in the initial order, talks about dismissal. Paragraph 7 is, here's my issue. The stay is obviously a judicial stay, discretionary in nature depending on the circumstances. Paragraph 7 switches control of the stay to the monitor. The monitor then decides how long the stay is going to last, right? So philosophically, I'm not sure that's the right way to go. I understand why you've done that. I'd be more comfortable with a series of court extended stays, because what that does is it gives people an opportunity, if they're concerned that maybe the stay should be lifted for some reason and they have to deal with Mr. Kinsman, they may feel that they'd rather deal with me than Mr. Kinsman on whether the stay should be further extended. Do you see what I'm saying?
I do. We just didn't want to bump up, since we were here, we didn't want to bump up to, we have April 18th, although we may be using that time for other issues.
Yeah.
That was the time when we were going to deal with the extension of the stay, and so if we're here and we thought that it essentially would be
I'm happy to hear you today, although I guess in fairness, anyone that saw that stay extension order would see that there's a hearing on the 18th to extend the stay. That's what the order says.
Yes, although they would be they would be seeing this in paragraph 17, but in paragraph 7, but I appreciate it's probably not highlighted.
Well, we don't know that everyone who has a potential claim that's subject to a stay has received notice of today. Right?
Well, the service list has.
Oh yeah, but there could be people not on the service list that are affected by the stay, in theory.
Yes, although other than they're not. It's not as if I'm going to have any different service on the 18th, because the exact same service list.
But they've seen the order online. They see the return date.
Okay, so
I'm inclined to think we keep the 18th, and you could even, unless there's some issue of controversy, if you even wanted to appear by telephone on that day, I certainly don't want to do anything that increases the administrative cost to either the CCAA or the bankruptcy proceeding. But I am a little hesitant about turning over jurisdiction over the stay to the monitor.
All right, so then perhaps by the 18th, we will know more in terms of a better timeline for when that last investigation report and activities approval will be coming forward, and then perhaps we can extend the stay till that date.
Yeah, that would be the idea, is we do it one more time to whatever that finish date would be.
Okay, and we will attempt to use the 18th to deal with any of these remaining issues that we have or anything else that would come up, but otherwise the stay would be the primary focus.
Yeah, okay. All right. Some of my questions we've answered already, so that's fine. Your paragraph 12, your release provisions, you've given me cases, you've given me orders with a whole range of language. This is probably the broadest of all of them in terms of the people it covers. I mean, I look at, for example, Justice Murphy's decision in the New Page case, which you were involved in. He had a much more specific clause in his, if we wanted to look at that.
I think in his case, he would have also had the plan, so the broader group of people who had releases may have been baked into the plan as well.
Okay. Yeah, it's paragraph 8. It's at tab 9 of your brief.
That's right, because it may have been in there that you had the plan as well, so others may have been
There may have been
involved.
release provisions in the plan?
Right. The others that we have provided to you had a variety of, had both monitor and the CRO were involved, were included in the other examples that we had provided. So, for example,
Yeah, which one would be, did you lift this out of one of those other orders, or is this different?
would have been a combination. For example, the Tomeko order,
Which
tab
is
9, tab 10.
Okay. What paragraph number?
Paragraph 9, that includes the CRO in that case.
But other than that, that's probably the closest language to what we're dealing with here, would you say?
That's right, or Can West, Justice Pepple's decision, which is at, Collins and Aikman, tab 11. Paragraph 5, tab 11.
Yeah.
Paragraph 5.
Well, it's got the qualification at the end that it exempts out or doesn't apply to claims arising out of negligence or actionable misconduct. So
We did use the language, yes, that we've understood.
the Nova Scotia language.
That's
so
right.
That's fine, and we'll leave it as is. I hadn't appreciated that in New Page there would be releases in the plan, and that's why that was more specific. Okay. The filing of the assignment of bankruptcy, I had asked in paragraph 14 whether there was intended to be a time frame so that the CRO would, once the stay was lifted, the CRO would file within a certain amount of time. Is it necessary to do that in your view, or just leave it as is? Because it's a fairly open time frame in terms of when the assignments would be filed.
Oh, it would be our intention if the order was granted today that would occur this week.
Yeah,
So if
okay.
you would like to include that, that's fine, but that is our intention that it would happen this week.
Well, if I don't think it's necessary to put the time frame in, as long as that's the plan. Obviously, we wouldn't want that to be held off too long because you want to get that underway.
Right.
So that's fine. Paragraph 17. Curious as to, I mean, I know I've seen that in other orders, but why is that necessary? It says that the applicants and a whole list of other people are restrained from disturbing or interfering with the trustee. Is there some suggestion that they will?
No, it's just, I think that's lifted, it is lifted from some of the other precedents that we have.
Yeah.
There is some parallel track where we will have at some you'll have that overlap with respect to the CCAA still being in place, and then the bankruptcy, so we don't want any steps being taken, but there's no...
But the trustee under the Act has all kinds of authority and protections. I mean, you wouldn't normally have something like this, or would you, in a receivership under the Bankruptcy Act? Would that be a standard?
The receivership language would have similar language,
yeah, it might be
yes.
similar to that. What about paragraph 18? Doesn't the trustee already have that power under the Act?
They do. Some of this, my lord, is quite frankly, it assists the trustee to be able to turn to the court order and say anyone who has books and records and should be cooperating with the estate. So it does assist in that way as well to be able to turn to that.
Well, I think I would take that out. If he needs to resort to some sort of court process because someone's not doing what they should do, then he needs to resort to the court process. So I think I'll leave in 17, but I would take out 18. And then we've already talked about the rep counsel fees and how we're going to handle those. That might, I'm not sure which paragraph, that might require some tweaking in paragraph 20. And maybe, yeah, probably in 20. Paragraph 21. I take it the superintendent didn't see any problems with paragraph 21? Deeming certain things to be compliance with the Act?
There's no comment that we've received from the superintendent about it.
Okay.
And that is really trying to already coordinate with the notice that has been provided, so there's no need to overlap there. And we now have rep counsel who's receiving that notice. Okay, well, if they're not concerned about it, I'm not concerned about it.
Paragraph 22, we're essentially ousting the jurisdiction of the registrar. I know there was the idea of some continuity. I'm not opposed to doing any of the stuff, but why are you thinking we should be automatically bypassing the registrar for all purposes?
Just given the nature of this case, where you've been dealing with all of the issues, and so you'll know what parties have done and haven't done along the way, and so that's why we thought it may quite frankly be faster to deal with it at one time at the end of the piece. So you'll have the inspectors dealing with it in the ordinary course, and then we would come to you at periodic times with respect to it.
But there may be times you want to go to the registrar, and now you can't. Because 192 has a number of things in it. It's not just the passing of the accounts. You know.
It is in respect to the passing of the accounts that we wanted to have.
Well, I know, but it says including the passing of the accounts. If all you want to do is say passing of the accounts will happen here, then you'd have to rework that. Because there's other things that, I mean, you'll have far quicker access to the registrar than you will to me in the normal course. And so depending on, for example, if, and I forget if this is covered by 192 or not, but let's say Mr. Kinsman wanted some sort of order directed to someone who's not doing something they should do. He can get into the registrar, is it every Friday the registrar is around? Anyway, whatever it is, it likely would be faster than trying to deal with me.
Well, my lord, I didn't want to step on your toes.
No, you're not stepping on my toes.
Trust me.
You're not stepping on my toes. I thought you might be constraining yourselves a little more than you needed to.
So we'll deal with it just to the passing of accounts.
That's fine. I can understand that. But the rest of it, and of course the section allows the registrar to refer issues to the court. So even if you went to the registrar and he said, no, I think that's something that should go to the court, then it can go there. And the court's jurisdiction kind of overlaps anyway. So I think it gives you more flexibility, I think, by leaving it only to the accounts.
And my lord, if at any point we think, given the nature of your involvement in this, if we think it should be coming to you instead, we'll include that in the notice of motion that we're asking to come directly.
Well, that's right. And I think that would probably trigger the registrar, if that's where it ended up, to just bounce it up automatically.
Okay.
My lord, it's Austin Iqbal here again. If I could offer a suggestion here in paragraph 22, instead of restricting it only to one specific head, where it says shall be directed, if we change the word shall to may, it gives us flexibility to do all of those things and also go to a registrar or come to you if it's appropriate.
I don't want to draft by committee, but that may be a solution, Mr. Iqbal. Thanks. My next comment deals with paragraphs 23 through 25, dealing with the issue of the omnibus claim and the confidentiality. I know from our prior dealings how the issue of confidentiality is important to the users. It's unusual, as you know, in a bankruptcy that you would have creditors who aren't known and aren't known to each other. But I take it again, the superintendent had no concerns about that being included in this order, obviously.
That's right.
Okay.
We have not heard anything with respect to that. And this is, the notice here is, and the omnibus proof of claim for the first creditors meeting, that'll just assist us in getting through the first creditors meeting, given the fact we have rep counsel. It may come a time that there needs to be some other level of disclosure with respect to the claims, but at this stage, it's very important. That message has come loud and clear.
Well, I understand that. There may come a time, particularly with opt-outs now, where the opt-out people may say, I want to know who the other creditors are, because I'm not sure they're all legitimate creditors for some reason, right? I mean, it's not unheard of for creditors to be expressing concern about other creditors in some fashion, and particularly now that we have opt-outs, that may happen, but that may be a discussion for another day.
Well, and that may be a discussion in terms of when we come forward with the claims process and how we address it at that stage.
Yeah. That's the end of my list. So I'm prepared to, subject to the things we talked about, and taking out that paragraph dealing with Mr. Ray's, I am prepared to issue the termination and bankruptcy order with those amendments.
So we can make those changes.
Okay.
Would you mind if we took a quick moment to then be able to...
I was going to suggest that we take a short break now. You can talk to Mr. Niedermeyer about the asset preservation order, and then we can move on to the rep council order after that, and we might actually get it all done today.
Thank you.
All right, why don't we take a break for 15 minutes?
All rise, please. Court is recessed for 15 minutes. Court is back in session.
Thank you. Please be seated. Okay, so I have a revised form of the asset preservation order that was just handed to me.
Thank you. Can I clean up one issue, my lord? You asked a question with respect to the opt-outs.
Yes.
And at the break, my friend, Mr. Kinsman, informed me that on the opt-outs, you asked about whether they'd been served.
Yeah.
On the opt-outs, there's 5 individuals. They've each been contacted, and they said they did not want to be on the service list. They did not intend, they have nominal amounts of claims, and they did not intend to be participating any further. So
okay.
I had thought they had actually been served, but they don't want to participate further.
All right, thank you.
So, my lord, we have worked with Mr. Niedermeyer with respect to this consent to asset preservation order. Mm-hmm. You'll see there's a number of block lines which I can walk you through. In connection with this asset preservation order, there has been disclosure provided to us through Mr. Niedermeyer by Ms. Robertson and the various corporate entities, and so that's why we have updated with respect to any corporate entities we found along the way, or the Seaglass Trust, for example. So that's some of the changes to just reflect the corporations that were determined, the banks that we're aware may be involved, and the exchanges that we're aware may be involved. So that represents a fair bit of the changes that you see. Paragraph 12, my lord. Just in terms of, so we have been provided with some disclosure, there still is some to be provided, and that should be completed within the next 10 days. Paragraph 13 then updates with respect to the banks that we're aware may be involved or may have been involved historically. Paragraph 14 This is on a practical note. So you have all of the accounts being frozen. There are arrangements with respect to living expenses and corporate preservation cost expenses that are being dealt with through the monitor and in consultation with the monitor. But for practical purposes, we've identified 2 accounts, both at the Bank of Nova Scotia, one for her personal account, one for the corporate account. There are a number of rental properties involved in which the rent needs to be coming in somewhere, property tax is paid from. And so 2 accounts have been identified. And so those will be the ones who are, for all intents and purposes, are unfrozen to allow these disbursements and amounts coming in. But you'll see it still is with the oversight of the monitor having an opportunity to see what is going on there so that it's controlled. Paragraph 15, we received some comments from others on the service list with respect to some additional records or statements, historical statements. They may be helpful. So that's the change in paragraph 15 was as a result of a request from someone on the service list, and it's on consent. 16 just identifies the potential exchanges that may have been involved or may be involved. And what the intent is then for both the banks and the exchanges is that we would go together and write to or contact each of these entities and institutions, go together and say, on behalf of the Quadriga corporate entities and on behalf of Ms. Robertson, the estate, and the other corporate entities behind Ms. Robertson and Mr. Cotton, we want verification with respect to what exists. So we would go out together hand in hand with that. Paragraph 19, my lord, I want to draw specific attention to, and we have in our report as well.
I read that in your brief. Yep.
It's important because when we're trying to monetize, when the estate has been trying to monetize, there's just so much publicity here, and there's concern for anybody, including bona fide purchasers, what am I getting myself into? And so on behalf of all of the affected users, it would benefit to make sure that purchasers understand they're buying good title here.
At least no claims of the applicants and the users.
Right.
I mean, if the company had no title to start with, this doesn't give a purchaser title, right?
Right. I think the concern that's being expressed is there anybody who's going to try to follow these assets and claiming through this estate? And we have consulted with Rep Counsel throughout about that. Rep Counsel is receiving also the disclosure as part of this at the Rep Counsel level. And they have been actively involved in this process in trying to reach the terms of this preservation order and with Mr. Niedermeyer. So if you have any questions, otherwise with respect to the terms, it is going on consent.
You confirm that, Mr. Niedermeyer?
Yes, my lord. The form that you have in front of you, I guess you have the black line copy. Mm-hmm. Apart from 2 very small changes to change the consent block to ensure that it includes the 2 other laterly added corporate entities, right. Megacorp and 2379164 Ontario Inc., and 1 defined term in paragraph 14, pardon me, in relation to Scotiabank. Otherwise, Ms. Robertson is consenting to those terms.
Well, not only Ms. Robertson, but all the other entities.
Yes, indeed. All of which she is directly in mind of.
Okay. And I take it Rep Counsel is fine with this to the extent that it impacts them?
Yes, my lord.
Okay, there you go. Very minor point, Ms. Pilon. Paragraph 20, the ability to come back on 4 days' notice.
Yes.
Well, is there some reason we wouldn't just say in accordance with the Nova Scotia Civil Procedure Rules?
That's fine.
Which would be, depending on the nature of the hearing, it could be 5 days. But that way, it's just, we've got different time periods and different orders, and it's probably just as easy to incorporate by reference the Nova Scotia Civil Procedure Rules, which also could include an emergency hearing if someone decided that for some reason giving 4 days, 5 days notice was somehow going to be harmful to them. They could come in and request an emergency hearing if that's what they wanted to do. But on notice to the monitor. Okay?
Thank you.
So I'm prepared to grant this order in light of the consent indicated by Mr. Niedermeyer with that 1 small change.
Thank you.
Okay, I think that disposes of the monitor's motion, does it, Ms. Pilon?
Yes, it does. Thank you.
All right, Rep Counsel.
Good afternoon, my Lord.
Good afternoon, Mr. McDonald.
As a preliminary comment, my Lord, we have a lot of material going through this afternoon, so I've restrained myself from jumping up and just supporting the various arguments made by the monitor, but I did want to echo something that Monitor's Counsel said in her most recent submission. Rep Counsel and through us, the official committee, have been collaborating with the monitor on a lot of these forms of order. There's been an excellent flow of information from the monitor, and we really appreciate that and the ability to bring forward the views of the affected users and put them into these orders, given their economic interest in the subject matter.
So you mean I picked the Rep Counsel?
Pardon me?
I picked the right Rep Counsel? Is that what you're telling me?
Of course, my Lord. A very wise decision.
I've looked at your materials. You're looking for two things, I guess, as I see it, in order to amend the cap on the initial Rep Counsel order from $250,000 to $400,000 in light of the additional scope of work that is described in your submissions. On that question, does anyone oppose? Anyone have concerns about that request? Ms. Pilon, I think, is the Rep Counsel indicates the monitor supports it. Is that so?
That is right.
Yeah, okay. It was pretty apparent to me that the extra work was done, Mr. McDonald, so I don't have any difficulty with that question.
Thank you, Lord.
The second aspect of it deals with the work during the bankruptcy exercise. You're suggesting, I think, that the order on a go-forward basis after bankruptcy not have a cap in it, but that there would be oversight of the work done and control of the cost of the work through the approval of the official committee, also approval of the inspectors of the bankruptcy estate, and I guess to some extent the fact that the trustee would be hopefully prepared to support that payment as part of the legitimate disbursements of the account, and that's where the oversight would come in. Am I summarizing your position accurately?
Yes, and the only thing I would add to that as well is in our submission, a removal of the cap once we're into bankruptcy also creates an efficiency, because we won't be coming back to court in the bankruptcy process as regularly as you do in a CCAA. And to have hearings simply to say, it's been 2 months, here's our new budget, we wish to move from this number to that number, everyone's in agreement, didn't seem like a good use of resources.
Is anyone concerned or opposed about that second aspect, the removal of the cap during the bankruptcy exercise? And Ms. Pilon, wearing your hat as the counsel for the soon-to-be trustee, is that, do you think that's a fair way to deal with it?
We support that, and I think that what's important is that it continues to be coming back either before the registrar or the court, because I think that's the concern sometimes with Rep Counsel, is that there's no final oversight, and so you continue to have that here.
Okay. Well, I'm prepared to grant both orders then, Mr. McDonald.
Thank you, my Lord.
All right, so have we got through everything on the list?
I think we have. Thank you.
Okay. So what we have left now, I'm going by memory, not on some list, is we have a couple of the third-party service providers who are working on language to deal with the aspects of the order related to them, represented by Mr. Linthwaite, Mr. Carey, and Mr. Hill. And if that can be done on consent, then you can fire the consent order over. If not, then it'll be returnable on the 18th of April at 9:30 in the morning for a final disposition. And then also on the 18th, the issue of a further stay will be addressed at that point, and hopefully by then the monitor/trustee will be in a better position to know how much longer the CCAA process will be unfolding. In other words, when the stay, although I suppose once the bankruptcy starts, do you still need the CCAA stay?
We will have that CCAA stay will extend over directors and...
Oh, I see, yeah. It goes a bit further. Yeah, okay. But anyway, you should be in a position to have a date certain at that point to shoot for any further extension. All right?
Perhaps, my Lord, sometimes, so if we were to send out the notice of motion for that 18th with the stay extension, perhaps what we can do is ask if anyone is going to be taking a position or objecting or opposing to that, that we hear from them 3 days prior or 2 days prior, and then we can advise the court if we need live to be here or whether we can proceed that way.
I think that's fair to do that, certainly for everybody on the service list. And in fact, you might as well, I would suggest, file at least the notice of motion sooner rather than later, returnable on that date, even if the material that will support how much of an extension might not get filed for a few more days. At least people are then on notice, and if they're concerned about the extension, it gives them more time to put their hand up and say they're concerned.
Okay.
And yeah. Anyone else have any other issues that need to be addressed today?
Excuse me. There's two, on the third-party processor, there will be some elements of that order that will be coming out without the need for continuing discussions.
Yes.
And so you'll see portions of that order coming to you then tomorrow likely,
Yep.
Including the language that we've dealt with POS and also the BC, Mr. Hill's client. So you'll see elements of that coming, and the balance will be on the 18th.
Yeah, that's right. Okay, well, in that case, we will adjourn to April 18th, and thank you for those that participated by telephone.
Thank you, my lord. Very productive. Thank
Thank
you.
you, everyone.
All rise, please. The sitting of the Supreme Court of Nova Scotia is adjourned until Thursday, April 18th, 2019 at 9:30 a.m. God save the Queen.